Our second speaker is Richard LeBlanc, right next to me. He is an associate professor of law, corporate governance and ethics at the School of Administrative Studies at York University, and he is also a friend. He's a lawyer and a specialist on boards of directors. He served as external advisor to boards that have won national awards and peer endorsement from institutional shareholders for their governance, for their good governance practices. Richard has conducted over 200 director interviews and has studied, analyzed, assessed dozens of boards of directors and boards in action. And this work is not only the entire board of directors, but also audit committees, compensation committees, nomination, and governance committees. Richard, we're delighted that you are here.
What I'd like to do is, I'm drawing my data from a chapter I wrote in Women on Boards last year, and a CICA, Canadian Institute of Chartered Accountants, publication coming out next week on governance of not-for-profits in Canada. What I'd like to do is talk about sort of where we are, picking up on some of the Senator's remarks, then my own research on competencies and behaviors. I'm a qualitative researcher. In fact, all of my ongoing research is interviewing individual directors and observing boards in action. It's not quantitative research. And I find that you can learn a lot from it's remarkable to me that corporate governance scholars don't study their subject matter. And most of the field tries to approach this from archival data, quantitative regression analyses, and trying to show a relationship between corporate governance and board effectiveness and corporate financial performance. And the literature is fairly conclusive here, as Professor Deere said earlier, that there's no conclusive evidence that there exists a causal relationship. So my work really is looking at not the relationship between board effectiveness and corporate financial performance, but boards themselves and how directors think. My work has been warmly embraced by women's groups and other sectors, which I'm pleasantly happy with. Including its focus on competencies and behaviors. And I've had an impact on the legislation in Canada in recruiting and assessing individual directors. We're one of the few countries in the world where you have a competency matrix to recruit under our national policy individual directors and assess individual directors. The UK and US, since the financial crisis, are moving in this direction of competencies, but up until the financial crisis, we had this legislation, which is recruiting and assessing on the basis of competencies and skills, and the UK and US didn't. And in fact, to this day, there is not a requirement to assess individual directors in the US. There is in the UK, but the US is moving towards this, and I'll speak to that. And then I want to move forward in terms of regulation and where the field needs to go. Pictures are worth 1,000 words, and I did a Google search on boards of directors image, and I came up with 2 or 3. This was the first one I came up with. So on average, if it's 9%, this or this with 2 women, actually this is above average, so it's either this one or this one. It's sort of like where the field is. And I think what we're hearing today is, that really is not good enough, and we need to move forward. The UK Prime Minister a few days ago said, when more than half of the graduates are women, it is completely unacceptable that some of our 100 public companies have not had a single woman on their boards, and none have a majority of women on their boards. And he went on to say that if things did not change, then more serious action would occur. I would submit to you that things are not changing, and leadership like this is important, but we need to ask ourselves, how are we going to move forward? And I think the Senator's bill is an excellent example of how we move forward, because the numbers really are not, in my view, and I've become a little more emphatic about this since I've begun to think about it, and also since I recently got tenure, is that the things really do need to change. Where are we now? We're roughly around constant, and the Harvard Business Review, in my second bullet point up here, this was last month. We don't know why. And that's a challenge to qualitative researchers, is when I see something like this, we don't know why. Well, I want to know why. And why, how do women experience and influence in the boardroom? Interviewing top women directors, which I've had the privilege of doing, and also top male directors, the sort of really progressive directors and the sort of not progressive directors. And here are some examples of the not so progressive directors. These are non-progressive, in my view and in our view, significant male directors in Canada. They're anonymous because I preserve anonymity when I do my interviews. Women are on the board because they wear dresses. There are only 20 women, and if you knew who said, and I would never reveal my sources, but there are only 20 women in Canada who are board ready. I get this comment a lot from significant Canadian companies that where are the women, and I don't get it because I think that there is a large enough talent pool. You just have to know how to look. And I think if your frame of reference and your vision, and I see this in interacting with male directors, is they like sameness. And I'm not sure they even know when they're doing it that they are perpetuating sameness. And as the senator said, it really is a self-perpetuating, self-selecting cycle in Canada. And shareholders really don't have a voice. I'm working with Ed on an op-ed right now on Say on Directors, where to think about this differently so that shareholders do have a voice. Women and CFOs and senior partners, this is terrible. They're used. I did this actually to be somewhat provocative, but it's these attitudes exist by male directors. Women on the board, but if a guy was doing the same job and the job was fifth class, they wouldn't be on the board. I must say she is very attractive, but perhaps my comment is better placed in the 1950s. I chaired during an all-male board meeting. The financial crisis. Let's go into what had happened. This is a conclusion from a significant study in Europe. The bottom line with the financial crisis, according to this report, is that the boards didn't understand, and what understand means competency, the risks that they were approving. And if your model is independent directors, which is CEOs of unrelated industries, on a significant banking institution board without understanding and I see this where directors admit to me interviews, I don't understand, Richard. And they don't want to admit that they don't understand because then they lose their credibility and their legitimacy and they appear ignorant. So the banks, the financial institutions that I've worked with, I've suggested a matrix, which you can't see here, but it's a list of skills and competencies along one axis and then individual directors along the other axis. And if you use this, then you should be able to produce, and all of the publicly listed companies in Canada have to use this now, the selection of directors based on competencies. So one of the banks I had worked with used this model, and they have 45 competencies, and they selected a female director in New York City that was a specialist and had 35 years of risk management experience to sit on the board of one of our chartered banks. And I made a presentation to the bank board. This is how you use the matrix. And they went and they did it, and they found a woman based on the selection of competencies. They found another woman, I don't want to be too specific, but it was a female CEO of a related industry, a 44-year-old female CEO in an industry that they needed on this particular bank board. So I think that this competency model works, but it really has not taken on, the traction has not been as significant as I would have thought it would have been, because the numbers really are still staying the same. And if this matrix worked, then the numbers would progress, and they haven't. I asked a specialist, John Hull at U of T, whether competencies should be relevant to bank boards, and this was his response, that yes, they should have 2 or 3 directors who understand derivatives and other complex financial products. They should also receive stress test results. You'd like to think that boards of our most significant institutions possess these competencies, but not all directors do. And part of my model is really an attempt to drive the nominating committee to select these individual directors based on competencies. The flaw with my model is that in the legislation under the national instrument, it doesn't compel publicly listed companies to disclose how they do this and the competencies of individual directors. Now let's go to the SEC. The SEC cited my work in July, and in December, they actually changed their law. So this is an SEC, a Securities and Exchange Commission. All the U.S. listed companies now have this law. In addition, for each director or person nominated, chosen to become a director, briefly discuss the specific experience, qualifications, attributes, or skills that qualify the person to serve as a director. So now all U.S. publicly traded companies under the Securities and Exchange Commission rule, 229.401, have to disclose, and they never had to before, the specific experience, qualifications, attributes, or skills that qualify the person to serve as a director. My critique in my letter to the SEC was these two words, briefly and or. And I think that the lawyers, panel of lawyers will approach this defensively. And briefly means 2 or 3 bullet points, and or means you can justify what you already have by selecting with certain words, like CEO experience, for example, or past resume type skills in 3 or 4 bullet points. So it's not rigorous enough the way this legislation is drafted to compel a company to disclose the level of disclosure that you really want. And I'm not suggesting that you put a CV on the web of each individual director, but this, I think, will be gamed by lawyers who are defensive. Let's talk about how I think lawyers will treat diversity. This is, as of last month, Securities and Exchange Commission, December, 2 months ago. This is the actual legislation. Describe the nominating committee's process for identifying and evaluating nominees for directors, and whether, and if so, how the nominating committee or the board considers diversity in identifying nominees for directors. The United States Securities and Exchange Commission has either very cleverly or very not cleverly not defined diversity. So the question is open for U.S. listed companies, and this is applicable now. So all U.S. listed companies have to start disclosing their diversity in the second one. Describe how this policy is implemented, as well as how the nominating committee or the board assesses the effectiveness of its policy. So you have to disclose your diversity policy, whether you have one, and how effective it is. But if you don't define diversity, the lawyers can approach it defensively, and they're already starting to approach it defensively. This is something I got earlier this week. The nominating committee does not have a formal policy with respect to diversity. However, the board and nominating committee believe that it is essential that the board members represent diverse viewpoints. Well, what does that mean, diverse viewpoints? Does this mean, and I've seen this in action, where white male directors will, under my matrix, indicate that they're diverse because they think creatively or they think laterally. So therefore, I rank really high on diversity. Well, that's arguably not diversity. So how you think about these individual skills and what constitutes diversity is an open question. And taking a positive viewpoint on the SEC legislation, if we believe that best practices of American companies, now that the lens is focused on this, will emerge, and through osmosis or through critiquing non-rigorous policies, that really good companies will emerge in their diversity plans, then you would like this legislation. If you're very cynical and think that it will be gamed by lawyers and be defensive, then you are not supportive of this legislation. You are not supportive of disclosure. You're supportive more of where the senator is going, which is we need more. We need more than just disclosure. We need perhaps percentages like Quebec did, or Norway, or France, or Australia. So what Australia has done now is, I'll go to my last screen and then I'll end it. So the disclosure of diversity plans, as the first point, is that's at a minimum where we need to go. And we have not done that in Canada. So there is no disclosure of diversity plans at the board level or senior management level in Canada. Australia, 2 months ago in December, said, if not, why not, have a diversity policy for the board and management, including measurable objectives related to gender. And one of the senators in Australia has said, and if companies don't reach the quota of 40%, there will be legislative imperatives to those companies that may include delisting of them or court action. This is one of the senators in Australia. And the French equality bill, as the senator has mentioned, is now 40%, and that's going through France. Quebec, and I was at a conference about a year ago where I was speaking to Quebec regulators, international regulators, and the person from Quebec said, listen, the directors exist out, and this is a bold step. And as the senator said, companies have not gone bankrupt in Quebec. So Quebec has essentially said, we want parity for all crown corporations in Quebec. And and the premier of Quebec, Charest, has said, we want you to go out and find female directors. And you know what? Quebec has done it. So, you know, it can't be that bad. So there is merit to having some sort of a bold initiative, like the Senators, or like Quebec's, or France's, or Norway's, to say, listen, we want to nudge you to get you there. Because otherwise, the numbers may not change. Even with disclosure, the numbers may not change because of defensiveness. So there is merit to pushing people from a policy perspective to say, listen, 50% of our graduates are women, 50% are women. You need to go out and find the directors because this is unacceptable, the situation that we're in. So I'm somewhere in between where the SEC is on disclosure and something that's a little more not intrusive, but realistic in terms of getting us there. But right now in Canada, we are noticeably absent. We should be leading the world on issues such as climate change or diversity or governance. And we've had a situation now where the CSA has come out and said, you know, because of IFRS and the recession, we're actually going to pull back on governance. And we've got countries such as South Africa, Australia, France, the US, and the UK that has significant corporate governance legislation over the last year or two since the financial crisis, and we are absent in key areas where Canada should play a leadership role, and diversity is certainly one of them. So further research, my last slide, is what does diversity mean? Qualitative research, and how females exert influence in the boardroom, particularly they tell me where 2 and 3 and 4 women are appointed. The dialogue changes. And I've seen it happen. And it absolutely does change. And then influence in policymaking. So I think that's it. Okay.